Chile, a South American country known for its robust economic growth and technological adoption, is no exception. This article delves into the intricate details of Chile's data protection laws, providing a clear overview for both legal professionals and the general public interested in understanding how personal data is safeguarded in Chile. The legal framework and regulatory bodies. At the heart of Chile's data protection efforts is the Personal Data Protection Law, PDPL, which sets the groundwork for the collection, processing, and protection of personal data. Unlike some countries that have established specialized data protection authorities, Chile does not have a dedicated regulatory body for overseeing data protection compliance. Instead, enforcement and compliance monitoring are handled by existing governmental bodies within their respective domains. Notably, the pro-consumer law empowers the National Consumer Service, SERNAC, with the authority to oversee compliance in consumer-related data protection matters, although it lacks the power to levy fines for breaches. Marketing communications and online privacy. Chile's approach to electronic marketing is particularly noteworthy. The country allows private entities to create and maintain databases for the purpose of sending marketing emails, provided they adhere to certain conditions, such as allowing recipients to opt out of future communications. However, Chile has yet to introduce specific legislation addressing online privacy issues, such as the use of cookies, leaving a gray area in terms of regulation and enforcement in the digital marketing space. Data processing and international transfers. One of the pillars of Chile's PDPL is its stipulation on the lawful basis for processing personal data. These include the consent of the individual, compliance with a legal obligation, or the protection of the public interest. Despite these provisions, the legislation remains silent on the requirements for international data transfers, which raises questions about the adequacy of protection for personal data shared across borders. Security measures and enforcement. When it comes to the security of personal data, the PDPL mandates data controllers to exercise due care but falls short of prescribing specific security measures. This vagueness puts the onus on organizations to implement their own data protection strategies, potentially leading to inconsistencies in the level of protection provided. Enforcement is another area where Chile's data protection regime shows its limitations. Without a specialized authority, aggrieved parties must resort to constitutional protective actions or civil litigation to address violations, which can be both time-consuming and costly. Defining personal and sensitive data. The PDPL provides definitions for personal and sensitive data, laying the foundation for what constitutes information that must be protected. Personal data encompass any information related to identified or identifiable natural persons, while sensitive data cover aspects of an individual's private life, including racial origin, political opinions, religious beliefs, health status, and sexual life. Conclusion. Chile's data protection laws represent a foundational step towards safeguarding personal data in an increasingly digital world. However, the absence of a dedicated regulatory authority and specific provisions for online privacy and international data transfers highlight areas where further development is needed. As Chile continues to grow as a digital economy, it may need to enhance its legal framework to offer more comprehensive protections for the personal data of its citizens and those whose data it processes.